Howdy, old-fashioned cowboys, cowgirls, vaqueros, y vaqueras. Bienvenido. Happy 250th anniversary to America. We've got a score to settle. That's right, folks. Today we're observing how qualified immunity is failing America and its people. America is plagued by incompetence, emotional dysregulation, unprofessionalism, and un-American sense of judgment. And it's the judicial branch's fault. Let's go down memory lane. The beginning of the end of the American dream began 7 years after the end of the Civil War, when the Supreme Court established that judges are immune from civil liability for judicial acts, even if those acts are erroneous or done in excess of jurisdiction, unless there is a clear absence of all jurisdiction. The immunity applies, which, ironically, resulted from a judge being confronted for being biased and insulting in manner. This case was Bradley versus Fisher. After Bradley versus Fisher, we had Pearson versus Ray, police qualified immunity. Then it was Stump versus Sparkman, which reinforced judges' qualified immunity. Last but not least, Harlow versus Fitzgerald, blanket qualified immunity for all government officials. Pearson versus Ray, police officers arrested black clergymen peacefully assembled on a bus. Once they finished their time in jail and paid a fine, they sued the officers, and the Supreme Court sided with the officers, saying they acted in good faith while performing their duties, which reaffirmed qualified immunity. Stump versus Sparkman, the Supreme Court reinforced that judges were immune from civil liability, even though it led to the sterilization of a child who never had a notice, a hearing, a guardian representation of her interest, or record of said sterilization being made. Harlow versus Fitzgerald, after a whistleblower was retaliated against by cabinet members of the president, then the Supreme Court upheld qualified immunity for those cabinet members, which removes all possibility of government officials not being held liable for any damages. These cases solidified the power within the executive, legislative, and judicial branches of government. Essentially, countering corruption has become virtually impossible. Since 1872, citizens' rights to seek justice or just compensation for the government's incompetence, negligence, hypocrisy, immorality, and outright neglect for upholding the law has become void. Over time, the government has been dedicated to a war on the rights of the citizens, which have been afforded to us by God and the Constitution. Nothing is sacred, secure, or safe. Not your land, not your property, neither your privacy, nor your life. Terry versus Ohio. U.S. Supreme Court case decides to allow law enforcement to conduct searches without a warrant if they can articulate reasonable suspicion of a crime being committed. Believes the detained individual is armed and dangerous and is limited to searching for weapons. Texas versus Brown expands what police can seize without a warrant, which is notoriously known as the plain view doctrine. It allows enforcers to seize items based on reasonable suspicion of illegality in plain view, which is left up to the enforcer's judgment. California versus Carney established that a mobile home, motorhome, can be searched without a warrant if it is readily mobile and located in a public space. Carroll versus United States. If enforcers have probable cause to believe a vehicle contains evidence of a crime, they can search it without a warrant. Holder Attorney General versus Humanitarian Law Project was a Supreme Court case that expanded on the USA Patriot Act, which stated nonviolent speech like training, advice, or assistance can be illegal if it is coordinated with or directed to a designated terrorist group. Smith versus Maryland. The Supreme Court enforces that citizens do not have a reasonable expectation of privacy in information you voluntarily share with third party. It allows the government to access large amounts of personal data without a warrant simply because that data is held by third parties. Timms versus Indiana. The Eighth Amendment's excessive fines clause applies to the states, limiting how much property the government can take through fines or forfeiture. However, they did not define what was excessive. United States versus Bahketajan. The Supreme Court of the United States struck down a forfeiture as violating the Eighth Amendment's excessive fines clause. However, again, did not define grossly disproportionate. United States versus usury. The Supreme Court of the United States allowed the government to treat civil asset forfeiture as non-punitive. In other words, civil forfeiture is not criminal punishment, so it does not trigger the double jeopardy clause of the Fifth Amendment. United States versus $8,850 in United States currency. The Supreme Court of the United States justified $8,850 being seized for 18 months before the claimant's due process was concluded. Again, the Supreme Court did not define a reasonable standard for due process. Austin versus United States. The Supreme Court failed the citizens of the United States again by not defining what excessive forfeiture was, which leaves a vast, unjustifiable, open interpretation of the law. Calero Toledo versus Pearson Yacht Leasing Co. This Supreme Court case justified property being seized through civil forfeiture even though the property did not belong to those who were using the property for illicit purposes. The property itself was leased. Bennett versus Michigan, the Supreme Court held that it was justified to civil forfeiture of property even though the owner had no knowledge it was used for illicit purposes. Then, the property was sold and the innocent owner was not compensated. United States of America versus $63,530 in United States currency. Mark A. Brewer. The Supreme Court allowed civil forfeiture of $63,530 even though the owner was never charged or found guilty of a drug crime because there was enough circumstantial evidence to suggest that he may have had a substantial connection to drug activity. Al-Assad versus Mayorkas. United States Supreme Court of Appeals for the First Circuit. The Supreme Court refused to take the case and allows the government to conduct warrantless searches of electronic devices at the border, and the only thing that is necessary is reasonable suspicion. United States of America versus Howard Weasley Cotterman. The Supreme Court denied looking at another vital protection of the Fourth Amendment and allowed the Ninth Circuit's panel's decision to allow warrantless searches of digital devices at the border. United States versus Flores Montano. The Supreme Court justified warrantless searches of a vehicle at the border, including not needing to provide reassembly of a vehicle even if the person is innocent. District of Columbia versus Heller. The Supreme Court limited the Second Amendment for individuals and did not extend it to militias being available to carry arms. Presser versus Illinois. The Supreme Court did not extend the Second Amendment to the citizens in its entirety, and it left the states with discretion to regulate militias or not. Wickard versus Filburn. The Supreme Court prevents farmers from allowing the people to own, store, or stockpile a privately stored farm goods even though it's not being sold on the market and it's on actively distorting the economy of food products. Michigan Department of State Police versus SITS ruled that law enforcement can set up checkpoints and detain without suspicion of a crime. Kalo versus City of New London. The Supreme Court ruled in favor of a private pharmaceutical company to claim eminent domain over private landowners. Berman versus Parker. The Supreme Court ruled in favor of district stripping private land ownership from a citizen even though they were providing a public service, so they could give the land to private land developers. Cole versus United States. This case solidified federal power by claiming eminent domain from a private owner who wanted the state to get involved in the case. Penn East Pipeline Co. versus New Jersey. A private company claimed eminent domain from the state property, and the federal company sided with the private company. That's all we have for today, folks. Thanks for coming out, cowboys, cowgirls, vaqueros, y vaqueras. Stay free, stay frosty, stay blessed.
There we go.
I'm injecting myself with steroids. Oh, you good, bro?
Aim at his head, not his body. Otherwise, it's not effective.
He's dead.